Yes.
All right, welcome everybody. I'm excited. You know, I did an interview with today's guest, Yitai Shao, also known as Linda, and she's got a very interesting story. And we just didn't have enough time to cover everything. We may not have enough time to cover everything today, but I wanted to follow up with her. I find this case to be very interesting. A little bit of background. Today's guest is attorney Yitai Shao, also known as Linda Shao. She's licensed to practice law in California for 21 years. Attorney Shao obtained her bachelor's of law from National Taiwan University, a JD from the University of Iowa Law School, and an LLM from Washington University, St. Louis. She had a few media exposures because of her history of outstanding advocacy in criminal defense and a very famous civil trial in San Francisco's court. Yitai Shao, welcome back. Good to have you here.
Thank you. Good morning.
Good morning. All right, so catch us up. Why don't you let us know a little bit about the background of the case, so the people who are watching it for the first time can understand what's going on. Tell us a little bit about the background, and then we'll get started.
Yes, basically I have 3 cases filed with the U.S. Supreme Court in 2017. The number of the cases, the first one is 17-82. Second one is petition 17-256. And third one is 17-613.
Okay.
The 3 cases was filed during the time span from July 2017 until present. The proceeding of the United States Supreme Court is when they have jurisdiction of 2 situations. One is original jurisdiction when you appeal from the 9th Circuit. Well, from the Court of Appeal. For my case, it's the 9th Circuit Court of Appeal of the United States. That is for 17-256 case.
Okay.
The other situation that the United Supreme Court has jurisdiction is based upon you exhaust the state court's proceeding and you have constitutional issues for the U.S. Supreme Court to decide. And for my cases, 17-82 and 17-613 fit into the situation when I exhausted my grievance up to the California Supreme Court and they denied review. Then the next step is to file with the U.S. Supreme Court. So the first step they accept, the first step of the petition is named Petition for Writ of Certiorari. The certiorari means writ. So it's basically petition for certiorari. It's just like a duplicative, but if the court grants review, that means the court grants, the Supreme Court grants certiorari, then we can step into the formal proceeding, have the case being heard, discussed. And all of the 3 cases right now, the first 2 cases of 17-82 and 17-256 were killed already. That means I filed petition.
Right.
They did not review. They did not recuse. And then I filed petition for rehearing, and rehearing were denied for 17-82 and 17-256. Now I have the 3rd rehearing, which is set for February 23rd, 2018, 2 weeks from now. And that is for 17-613. And the major issue there will be the United Supreme Court, 8 justices failed to decide my requests for recusal, which were filed in 17-256 and 17-613. 613's petition for writ of certiorari as well as for the rehearing stage of 17-256 for both requests for the recusal, they failed to decide. They abdicated their judicial duty not to decide. And my cases are the first one in the history of the United States, as well as the history of the U.S. Supreme Court, that they failed to decide on requests for recusal. Request for recusal have been so important to form the fundamental justice, the fundamental framework of justice of the U.S. laws that must be decided by every judges, every court when this issue come up with the court. And in the past 225 years history of the United States courts, it has been decided. Even for the U.S. Supreme Court, there were many cases of requests for recusal, whether they gave our reason or not for request for recusal, they have to decide. That's a constitutional duty, and that's required by the Code of Conduct for United States judges.
Okay, so let me ask you this. When you're at that Supreme Court level, Linda, and somebody, okay, so you're asking for one judge to recuse themselves, or were you asking for all 8 justices to recuse themselves?
This time I'm asking for 8 justices to be recused. Before November 30, for petition number 1782 and 17-256 at the petition for certiorari level, I was not aware of the financial interest, conflict of interest of the 8 justices. I was only aware of the conflict of interest, the direct conflict of interest of Justice Kennedy and Justice Ginsburg. Only the 2 justices, because they established American Inns of Court in their name. Their names are associated with the American Inns of Court. So they have direct conflict of interest. And the issues for all 3 petitions that I filed with the Supreme Court since July 2017 have been focused on the issue of a lack of impartiality of the court. And one of the major issues discussed are about the function of American Inns of Court, the interaction between attorneys and judges inside this big organization of American Inns of Court. So before that time, my focus was on the issues of the direct conflict of interest of 2 justices only. But since another attorney supplied me information on November 30th, 2017, that there were actually 8 justices I should have mentioned. Then I discovered, then I filed requests for the recusal, and these 2 requests for recusal for case 17-256 and 17-6134.
Hold on a second, because okay, so give me a little background information. So case, what is it? 17. What's the first case?
The first case is Linda Shao versus McManis Faulkner, James McManis.
And that case is what? 17 what?
17-82. That is
82.
Right. That is the case appeal from the California Supreme Court's denial of a review, and that is a case initialized from Santa Clara County Superior Court. The case title is Linda Shao versus McManis Faulkner LLP. It's a law firm.
Okay.
And McManis and Michael Reedy.
Okay, so that's 1782. What's the other case?
17-256, the second one, which is identical respondents, identical McManis Faulkner, James McManis, Michael Reedy, but that's in the federal court. So that was filed with the U.S. District Court in Northern California, was pending with the 9th Circuit And so the Supreme Court has original jurisdiction regarding that one.
Okay, so just so we're all clear, so the first case that you filed, the 17-82 against McManis and et al., all the parties involved, you filed that case. Why?
Because I filed a motion with the 6th District California Court of Appeal asking to reverse an order of vexatious litigant orders against me, which was made by McManis Faulkner Law Firm from its own client, Santa Clara County Superior Court, against me without any evidence. And I asked the 6th Appellate Court of California to reverse the order based upon violation of a fundamental due process that an attorney, as an attorney to the court, cannot appear as a party in front of its own client, and when in substance they are also judicially just corrupted, it just cannot be sustained. So
okay, so I just want to clarify this. So you filed this the 17-82 because you found out, you discovered later on that there was a conflict between McManis and the court that you were in. Is that right?
Yes, that's correct. I discovered the conflicts and direct interaction in 2015 and has been asking for change of court. And now the jury trial was stayed wrongfully by the Santa Clara County Superior Court. They tried to block this case to go to the jury trial. And,
gotcha.
and so I filed, and they in order to block me from access to a court, they obtained from their own client, Santa Clara County Superior Court, to block me by way of vexatious litigant pre-filing order, which was mysteriously issued when this order was never shown on the docket of this case. So I asked the 6th Appellate Court, I need to change court. I want to change Santa Clara County Superior Court. I want to change California 6th Appellate Court as well, because James McManis also testified in July 2015 during his deposition that he has one client in the 6th Appellate Court. And beyond that relationship, attorney-client relationship, I further discovered that there are so many justices that have regular social relationship through two chapters American Inns of Court with the respondents. So the respondents have been be able to manipulate the courts, California courts, by way of American Inns of Court.
Okay,
Yes.
So let's do this. That way we can stay on target. Okay, so you file these cases against McManis and because of all the conflicts. Then later on, as this is evolving, you find out about a relationship between Inns of Court and the justices. And so why don't you quickly summarize the basis of your allegation that these justices should be impeached and their connection between Inns of Court. Why don't you clarify that for us?
Yes, okay. So are you talking about the Supreme Court level, or are you talking about the lower courts level?
No, I'm thinking about the higher court level. The facts that form the basis of your allegation that the justices should be impeached.
Okay, so basically, because I want to change court, because I want to reverse the orders of the trial court, I filed the motion to change both the court appeal as well as the state court, the trial court, and this motion was denied. And I follow the proceeding, filed a petition for review with U.S. Supreme Court, and that's case number 17-82. So the key issue in the petition involve the function of American Indian Court. That is, that one major issue discussed there, that I ask the U.S. Supreme Court justices please certify the question involve the issue that whether when attorneys and of course they are members of the American Indian Court, shall the attorney be required to disclose their relationship, and shall the judge be required to disclose their relationship? And that's the relationship based upon the regular social relationship. If the judges are in the executive committee, that they have regular social relationship a year at least 14 times. And if they are regular, if the judge is not in the executive committee, well, at least 7 times, still a lot, regularly every year. And besides that kind of meal, the closed meeting, meal conferences that they eat, that the judges eat free for the conferences. Beside that, the judges also provide mentorship to the attorneys. And I think I stated it before, for the William A. Take for one example of Santa Clara County area, that is a chapter called William A. England American Indian Court. That chapter has 100 to 110 members. This was testified by respondent Michael Reedy. He testified that among the 100 to 110 members, there are about 30 judges and justices there within the geographical limit of Santa Clara County. And how many attorneys are there? 60 to 70. That means 2 attorneys versus 1 judge. They have very close relationship by way of this setting a private club with the membership not available for the public's access. They can have free email access to the judges 24 hours. They can send emails and contact the judge. They also have a pupillage groups. So take, for example, for this England Indian Court, there's William A. England Indian Court and the American Indian Court. They have 6, if I remember correctly, 6 pupillage groups.
Okay, 6 privileged groups. Okay.
And so they got performance. They arrange performance with the judges in a private time to have this pupillage group presented during their meetings. So they can have contacts. They can go to the chambers, the judges. They can have meetings privately with the judges. That is beyond the opposing counsels know what did they talk.
Right. So you're saying that this relationship, the fact that this relationship is close, that they need to disclose the relationship and really not just disclose the relationship, but really disclose the level of relationship, because it sounds like the allegation is that the relationship between these attorneys and these judges are too close. They're not just regular professional relationships. We're talking almost like a club, if you will, right? A very close relationship, which can, what do you call it? Just because people are human, these type of close relationships will, what do you call it? Color an attorney's feelings or a judge's feelings, and sometimes put the proceedings at risk, or put a client at risk, or something like that. And as you were saying, it gives the opposition an unfair disadvantage.
It gives the appearance of a bias and prejudice. So that's the reason why such function directly violates Rule 5-300 of California Rules of Professional Conduct. Rule 5-300. You can find that on the website of the California State Bar, and that rule has been adopted as United States, even though it's California rules of court, it requires no ex parte communication between attorneys and judges. And also attorneys cannot directly or indirectly provide gifts to the judges. So that is Rule 5. It not only includes judges, but also includes the judges' staff. So subdivision C of Rule 5-300 requires the employees, the staff of the judges not to accept gifts as well, not to have ex parte communication with the attorneys as well. So this, I believe this club, fundamentally, their function violates law. It's just created the appearance of bias and prejudice. And we don't have to dig into the specific detail evidence whether there was actually happened, but it's just appearance. The public confidence about the judiciary will be stricken, disrupted because of such relationship. If you browse into the
let's talk about this real quick. I just want to clarify this for our viewers. When you say ex parte or no ex parte communication, what is ex parte? Explain that in layman's terms so everybody can understand.
Ex parte means one side. That means
right. One side is meeting with the judge, and the other side is not aware of this meeting. So they're the the ex parte is.
One side means for litigation there's plaintiff and defendant, two sides, two parties, and one side is only one party, either plaintiff's attorney or defendant's attorney. They communicated with the court without the knowledge of the other side's attorney or a party. So that's so-called ex parte communication, which is illegal, unlawful, unethical, should be reprimanded.
Right. And I like the way you said it is, look, maybe nothing was done wrong, but it looks like it. There is this confidence that is lost because this ex parte communication makes people wonder what is going on. And and that's why it's illegal. That's why it's unlawful. It's unethical. All of these things stack up on it. And absolutely, the judges as well as the attorneys, because everybody's a court officer, needs to avoid the appearance of impropriety. And this is what we're talking about. It looks bad, and I agree with you. It's just, I don't know. It's just not done on a regular basis. And that's why there's a rule for it, right?
Yes. And so that is the basic, the key certiorari question I presented to the court, U.S. Supreme Court, in all three petitions. I was asking the court to decide that as a matter of law,
right?
And will this kind of relationship create appearance of bias and prejudice that the court should declare to forbid such a function of the American Inns of Court.
Yes. All right. So let's talk about this, because I want to bring this up. I find this to be also interesting. So besides what the allegations of the justices, I want to talk about the possible disruption or corruption of the clerk's office of the U.S. Supreme Court. Talk about this a little bit. This also, I think, occurred around January 8th, 2018, so just really last month. So talk about your experience with the clerk's office.
Yeah, thank you very much. So for the U.S. Supreme Court this time, they're regarding, because the issues I presented for petition are so sensitive, and I believe because the respondents are very powerful in this cup, because James McManis received the highest honor. He is the honorary bencher that is the highest honor of the Inns of Court. That means he donated a lot of money by way of by way of American Court, he elevated his status. He caused him to be very famous. He caused himself to be able to provide free legal services to so many judges, justices in California, and I'm not aware, maybe in Washington D.C. as well.
Sure.
He testified. James McManis testified on July 20, 2015, that he provides free legal services regarding these judges and justices' personal affairs.
And this free legal service really comes down to a gift.
Yes, it is a gift. That means James right. So California State Bar did institute an investigation case against James McManis. However, because James McManis is also in a very high position and very influential person right now for the State Bar of California, half a year later, suddenly the casework was removed and the case was suspended by the State Bar, stating that we want to wait until the case, the trial of Shao versus McManis, Faulkner, James McManis, Michael Reedy, to be determined. And in the meanwhile, they have stayed jury trial beyond the 5 years. I mean, they have stayed jury trial from December 2015 until now. They just don't want to have the trial to go on because they don't want the judicial corruption evidence to be exposed to the public. They want to kill, they want to suppress, and that's the reason why I want to change the court. So change court is a key issue pending with the courts. Then what happened for the U.S.?
Right now, in front of the court, there is a motion to change courts.
There is an appeal from the court's denial review, the California Supreme Court's denial review regarding 6 appellate court appeals denial of my motion to change courts.
Okay.
Reverse the vexatious litigant order against me.
So let's talk about this vexatious litigant thing. When they put this label on you, it's almost like giving, and you correct me if I'm wrong, when they put this kind of label on somebody, it almost denies them access to the courts. They are treated completely different.
Yes, but the thing is, they later on when the court declared vexatious litigant, it didn't mean the vexatious litigant cannot file anything.
Right.
But later on, several days later, there was a very fishy order came up. That was vexatious litigant pre-filing order, and that pre-filing order was not included in any statement of a decision. And however, by way of the case law require, if you have any vexatious litigant pre-filing order, the court must state a reason. There's no reason. It's not there. It's just like a ghost order suddenly show up, and it was not even entered by the clerk into the case docket. So how this came up? The only person who can do this is James McManis, because he is attorney for Santa Clara County Superior Court. And he represents the clerk, he represents the clerk's office, he represents the courtroom clerks, he represents so many judges. Besides, he also represents the entire institute of Santa Clara County Superior Court. So only he can do it. So
right.
now,
okay, so let's talk about this real quick because we're almost out of time. Okay, so can you wrap this up for us? Give us like a snapshot or advise us what laws have they violated. I mean, we talked a little bit about the impropriety, the appearance of impropriety, the ex parte stuff. What else have they violated? We also talked about the gifts between what is it, James McManis, these attorneys who are giving gifts or in different various forms to these judges. Talk a little bit more about some of these laws that they're violating.
Okay, so Rule 5300 is a law, the ethical rule that regarding James McManis violation. But I think we are almost interested regarding the Supreme Court's violation, right? So regarding the 8 justices, they failed to disclose their the gifts they received for the when they sponsored the 38 clerks. And I was asking you if you could do me a favor and posting the link on this site regarding the Temple Bar Scholarship. That is a key issue. The financial interests of the 38 clerks and 8 justices. If you could post it, I truly appreciate. And so that there is undisputed evidence. We are talking about not the factual issue speculation. We are talking about the matter of the law, that the number one problem with the 8 justices that they should be impeached because they violated the canon of a code of judicial conduct. They violated the First Amendment and the 14th Amendment of the Constitution. They violated Article 3 of the Constitution in failing to decide my request for recusal. That's number one. And number 2 is they failed to disclose their conflict of interest. They failed to disclose how much money they received pursuant to which were required by 28 U.S.C. Section 455B. They failed to comply with the disclosure requirement of Section 620.35 of the Guide to Judiciary. When they receive gifts, the annual maximum amount should be $100. Each event should not more than $50. But now we are talking about huge money. It's about $7,000 for each clerk. And for the 38 clerks as published on the website of the American Inns of Court under the section of Temple Bar Scholarship, the aggregated amount as shown there are estimated to be about $266,000. That's I don't know how many times, tens of 1,000 times.
Sure, but
judicial limit.
And the way I look at it is this: look, whether it's $1 over the amount, let's just say that they're receiving gifts, and to me, it almost doesn't matter the amount. It's the lack of disclosure, because
Yes.
even if they receive the proper gifts, then you still have to disclose that, hey, we received $700 worth of gifts from this person or that person. It's just the law, but they have to disclose it. In this case, they didn't disclose anything. So whether it's $1 over the amount or $1,000 over the amount, to me, it doesn't matter. They didn't disclose anything. Is that right?
That's true. They have to disclose because these are gifts, and as defined by the Code of Judicial Conduct, as well as the Guide to Judiciary Policies for the U.S. judges and their employees, they have to disclose no matter what. They have to disclose gifts, and these gifts are not exempted from disclosure because they are specifically targeted based upon their judicial position. So their official position with the United States, that means they are the gifts, the Temple Bar Scholarship are given to only the clerks, law clerks working for the U.S. Supreme Court justices or for leading U.S. Court appeal. So that means these law clerks, they provide legal analysis, they provide recommendation to the judges about how to rule for the petition for writ of certiorari, how to rule on petition for rehearing. So they have direct conflict of interest. So very simple, because my case, the focus, all 3 cases are talking about American Inns of Court, and they have conflicts. They receive financial interests, substantial money. They have to disclose, and they should recuse themselves in substance as well. Even though fundamentally, you mentioned that, I think you were saying that disregard if that is correct, right or wrong. They must disclose.
Right.
Right.
I mean, the way I look at it is this: if I was a judge and I want to avoid the appearance of wrongdoing, it makes perfectly good sense to just disclose the information, right? I mean, because it makes you look good when you disclose the information. And I'm gonna put up this blogspot link here real quick. But that's my whole thing, is that when they fail to disclose the information, that right there should be a red flag to everybody. Right.
And also, you mentioned about U.S. Supreme Court's clerk's office irregular situation. They deter my filing. They refuse to file in a 17-82 regarding amicus curiae motion of mothers of lost children. That violated their duty to file. The duty to file was codified. Let me see here.
Linda, I'm getting a signal from my producer. Time is up. Go ahead and tell us that little bit. What is that? The amicus curiae from, what is it? Mothers of
lost children.
Mothers of lost children.
Right. Mothers of lost.
What I'd like to do is pick up. Let's pick this up tomorrow if you have time. Let's get together again in the morning and let's move this further, because again, this story is so amazing, and I'd like to do a follow-up interview with you tomorrow.
Okay. Thank you very much.
All right. Thank you so much, and we'll talk to you tomorrow.
Thank you.